Hi there. I hope everybody had a great Memorial Day weekend. Today I'm going to talk about the $550 million settlement that Santander entered into with over 30 different states to settle claims of predatory auto lending to low-income and subprime borrowers. I'm going to talk about the nature of predatory lending, what laws prohibit predatory lending, what Santander allegedly did to violate those laws, and finally I'm going to talk about what banks and fintech companies can do to avoid enforcement actions based on predatory lending practices. Regulators tend to use the phrase predatory lending to describe a number of different unlawful practices within the field of lending. And there's really no checklist to determine whether or not a specific loan or a specific loan program constitutes a predatory loan. And that's partially because the exact same loan and the exact same loan terms can be great for one borrower and terrible for another. But there are a number of different features of loans that have been commonly associated with loans and loan programs that have been found to be predatory. So, for example, one of them is when a lender loans money to someone based on the assets they have instead of their ability to repay. A second is when a lender induces the borrower to refinance the same loan repeatedly. That's called loan flipping, and it's often done in order to generate high points or high fees paid from the borrower to the lender each time the loan is flipped. And then finally, there's just fraud. So in instances where a lender deceives or conceals aspects of the loan obligation from the borrower, particularly when the borrower has been found to be unsophisticated. Enforcement actions against banks for predatory lending are often actually based on these very general state or federal laws that prohibit unfair, deceptive, or abusive acts or practices against consumers. And those laws actually have very general language, and the language often leaves in the eye of the beholder whether or not a specific practice is unlawful. So, for example, Section 5 of the Federal Trade Commission Act prohibits unfair practices. But what does that mean? It means that it causes or is likely to cause substantial injury to consumers, which is not reasonably avoidable by consumers themselves, and not outweighed by countervailing benefits to consumers or to competition. But those standards still leave in the eye of the beholder whether or not a violation has occurred. For example, when is an injury reasonably avoidable by a consumer when many aspects of the loan have been disclosed to the consumer? Or when is aspects of the loan that is made to the consumer outweighed by benefits that otherwise accrue to the consumer? All of these things end up being in the eye of the beholder, and that makes things very difficult for banks and fintech companies. The states accuse Santander of engaging in a number of different unfair and deceptive acts and practices when it extended auto loans towards low-income and subprime borrowers. For example, Santander was accused of having very sophisticated systems for predicting whether or not the borrowers would ultimately default, and is accused of having extended loans to individuals even when its own models predicted that those individuals would never be able to repay the loans. And Santander did not disclose that to the borrowers. In addition, Santander is alleged to have allowed auto dealers to send in false information about borrowers. In particular, the amount of rent or mortgage payments that these borrowers were paying every month was a very important part of the application, and the dealers would put in unrealistically low numbers. So, for example, in an area where the average rent was $2,000 a month, they would put in $500 a month. And Santander allowed that falsified information to be used and would extend loans. So because of this conduct, the bank ultimately agreed to pay $550 million. And what was in that $550 million? Well, it's a number of different things. Some of them are payments to the states, some of them payments directly to borrowers. There's also some administrative fees. But the overwhelming majority of the $550 million is actually loan forgiveness. So a number of those different borrowers, including some of the borrowers who are still making payments on loans, and some of the borrowers who still have outstanding obligations to the bank, are going to have aspects of their debt completely forgiven by Santander. It's actually harder than you might think for a bank to avoid making any predatory loans. The reason for this is that you can't tell just by looking at the loan documentation whether or not the loan is predatory. Also, the specific circumstance of the borrower matters. So their level of sophistication and their specific financial circumstances. Because of this, it's very important for a bank to monitor the point at which the borrower provides information to the bank. This makes it dangerous when a bank relies on a third party to obtain that information, such as an auto dealer. And we've seen the same problem not just with auto dealers, but also with mortgages. So for example, when a FinTech company originates a mortgage loan application, the bank is not dealing directly with the borrower and has to rely on that FinTech company's information. So it's very important for the financial institution to monitor a third party when they rely on them for that information. It's also important for a bank to document both its policies in this area and how it implements those policies. And this can be very difficult because the regulations that govern predatory lending are constantly changing. And in addition, regulators' interpretations of those regulations are constantly changing. But good news, I'm a lawyer. So if you have any questions about whether or not your lending practices could potentially constitute predatory lending, give me a call. I'd be happy to talk it over with you.